Welcome to the Law Awareness Weeks at CDC 2025. This webinar is part of the Law Awareness Weeks at CDC 2025. It is a collaboration between Pro Bono SG, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Counsel Association Pro Bono Chapter, and the Singapore Association of Social Workers, supported by the People's Association. I'm Hannah, and I'll be your host for today's webinar. First up, Muslim Albakri. He's a partner at Lighthouse Law LLC with over a decade of legal experience. Before joining Lighthouse Law, Muslim led a boutique practice for 6 years, where he advised clients on areas such as dispute resolution, criminal defense, commercial transactions, and Islamic estate matters. Muslim also regularly advises on a range of corporate matters, including shareholder agreements, investment contracts, employment law, and regulatory compliance. His clients span various industries, including financial services, events and media, and non-profit organizations. Muslim is also actively involved in community and pro bono work, including long-standing service with the Law Society of Singapore's Criminal Legal Aid Scheme and Justice Without Borders. Welcome, Muslim.
Thank you, and good evening, everyone. Thank you for having me here.
Next up, we have James Lim. He's the Director of Program at Lutheran Community Care Services, overseeing programs that support children, youth, and families. Trained in restorative practices by the International Institute for Restorative Practices, he works with schools across Singapore to strengthen relationships and resolve conflicts through training, consultancy, and restorative cycles. He believes that building, strengthening, and restoring relationships is the key to helping children thrive. Welcome, James.
Good evening, everyone.
And last but not the least, we have Aaron Scott Donovan. He is an assistant senior social worker with Fei Yue Community Services, serving in the integrated service provider team for youth development. With over 5 years of experience in youth social work, Aaron works closely with in-risk and at-risk youth, including those disengaged from education and employment, such as hidden youth and NEET youth. His primary focus is in youth offending intervention through guidance programs with a specialization in addressing harmful sexual behaviors in adolescents under GP PAST. Welcome, Aaron.
Hi, thanks, Hannah. Hello, everyone.
Muslim, James, and Aaron, thank you very much for joining us today. With that, we will kick things off. Very interesting and important topic today. We will cover what happens when a young person breaks the law, how bullying and harassment specifically are treated under the law, and the roles of the different players, the schools, the parents, and the justice system. You will also hear about early intervention strategies and support options available to guide youth back on track. This session will offer you practical legal insights and tools to help you support young people with clarity, care, and accountability. Now, with that, let's get started. Let's begin today's session first by looking at how the justice system in Singapore deals with a young person who commits an offense and what happens if a young person is arrested for committing an offense. We turn first to Muslim. Muslim, can you share with us, as a starting point, whether it's even possible for a young person to be charged with a criminal offense in Singapore? And how does the law deal with these sorts of situations?
Okay, thank you for the question. In short, yes, it is possible for a young person, a child even, to be charged with a criminal offense in Singapore. Essentially, the minimum age for criminal responsibility was increased in recent years from 7 years old to 10 years old. So it currently stands at 10 years old. And what that essentially means is that a child of 10 years and above can be held legally responsible for criminal acts by a court of law in Singapore. Now, I should add that between the ages of 10 to 12, it's not automatically presumed that the child, can have the sufficient maturity to be held criminally liable. So in situations like that, the court will be interested in ascertaining first and foremost whether that particular child has the sufficient maturity to understand the nature and consequences of their action. And only then, if the child is demonstrates that level of sufficient maturity, then action will be taken by proceeding with a charge. In the case of a child offender, it typically takes place in the youth court, which we will happy to explain further later on. Yeah.
Okay. So what actually happens when a young person is arrested for or suspected of committing a criminal offense? Because even if we look at, let's say, a 12-year-old, that's still a pretty young age. Do we expect that they will be arrested and treated in the same way like an adult offender would?
Okay. So I think in the first place, usually when a person is arrested, an individual is arrested under the law in Singapore for a criminal act, the police tend to work fast within the first 48 hours to carry out some form of preliminary investigations. And why I say 48 hours, because that is the deadline under the law, under which they can detain an individual for investigations before they have to be released or otherwise be presented before a judge to extend that detention. So that first 48 hours is quite critical, and it is usually during the first 48 hours that the police will record initial statements from the accused person. Oh, sorry, not the accused person, but the perpetrator, let's call it. So in the case of young offenders or young individuals, the same would apply, right? When a young individual is arrested, you would expect that the first 48 hours are critical in allowing the police time to complete preliminary investigations to come to some form of landing on whether there is an offense that's made out. In a case of a young individual, however, the law requires an additional safeguard. So there is something under the law called the appropriate adult scheme, which requires a trained individual adult to be present during the investigations and primarily during the recording of the statements, right? To ensure that the young individual understands the process, is not intimidated, is not coerced into, into saying things that they don't actually mean and things like that. So whilst the young individual would be expected to go through the same investigation process, what I would say is that there are safeguards in place to try and mitigate the harm, to try and help them through it, to try and navigate them through this delicate situation. In most cases, after that initial period of arrest or detention for investigations, a young person would be released on bail, meaning they would be allowed to go free, as long as an adult or a guardian, puts bail up for them and secures their continued cooperation with investigations, so on and so forth. Okay, but in other cases, if an offense is made out or the authorities think that the offense is sufficiently serious to proceed with a charge, then it's at that stage that the person is put through the youth court, essentially. Yeah.
Okay, so as a parent, if my child is arrested for suspected involvement in criminal offenses, can I be the appropriate adult that sits in with them during any police interviews, or can I in any way participate in the interview process so that my child doesn't have to go through it alone?
Okay. Unfortunately, the practice usually is that the parent is unable to be the appropriate adult standing in for the interview. It's a person who is trained for the situation and has no real connection with the individual at hand. I mean, unfortunately, that appears to be the reality of the situation, and I think that's also to just, it's mainly to allow investigations to be carried out with minimal fuss and interruption. I think,
Okay.
more of that rather than to prevent an adult or a parent and a guardian from being involved in that process. Because as far as I'm aware, even when a young individual is being charged, even if the parent is not allowed in the statement process, as part of the statement process taking, my understanding and my experience from my clients is that the police do try and the authorities do try to make a concerted effort to keep them involved, to keep them notified, and make sure that they're not kept in the dark, kept them involved. But, that the initial statement taking process under Singapore law is very critical. So a lot of things, unfortunately, need to see to that. Yeah.
Okay. Yep. So it sounds like there are still some fairly significant differences between the way we treat an adult offender and a young child who might have committed an offense. So just zooming out a little bit, could you share a little bit with us on what is our court's philosophy on youth offenders and how do we generally take care of them in our society?
Okay, I think when we talk about youth offenders, the general attitude and approach under the law, be it whether it's with the courts or with our enforcement authorities, the general approach is quite similar, right? It's twofold. First, it's about identifying the relevant sentencing factors that apply to a particular offense. And under the law, where a young offender is concerned, the predominant sentencing consideration is one of rehabilitation. Okay, meaning rehabilitating the young offender, helping them to reintegrate back into society, right? In cases of more serious crimes, there could be other sentencing considerations which take equal precedence. For example, deterrence, making sure that this doesn't happen to other people, or even retribution, making sure a victim feels justice for their wrong, right? But going back to the approach under the law, it's about identifying the sentencing consideration first, and then thinking about what is the appropriate response under the law to meet this sentencing consideration. And this applies even before it goes to court, because unlike adult offenders, when it comes to a young offender, the authorities do consider at an early stage whether the appropriate response under the law should be more interventionist in nature as opposed to institutionalized. And what they can do is they can direct these young individuals to undergo guidance programs instead of being charged in court. And if they satisfy the conditions in the guidance program, if they successfully complete it, then they don't have to be prosecuted. So that is one of the best illustrations of how the law treats young offenders, right? Even if the offender is sent for institutionalized justice, right, going through court, the young offender doesn't go through the same type of court as an adult offender, right? It goes through a youth court, which is a specialized court meant to be tailor-made for young offenders. Yeah.
Yes, and we'll talk about the youth court procedures in a little bit. For now, maybe Muslim will give you a short break. We'll go over to Aaron and we'll talk a little bit about some of the programs that are available generally for early intervention and rehabilitation. Aaron, can you share with us some of your experiences around this topic?
So actually, Hannah, there are several programs out there available. There are upstream programs that actually target to set in place to support youths who are at risk. But let me share two of such programs lah. So firstly, one would be the Youth Go program. The Youth Go program is a program that works towards preventing youth at risk from committing offences. So these are youths that have not committed offences, but they display risk issues that we identify as precursors that might lead them to commit offences lah. So social workers engage and intervene with these youths who they get to know through street outreach or through referrals from sources such as schools. The program supports youths who possess pro-criminal attitudes, those that displays verbal and physical aggression, or those who have associations with negative peers. So through casework, counseling, and engagement in interest-based activities, the social workers aim to strengthen these youth protective factors and in turn also then reduce their engagement in risk behaviors. Right, so this is a youth co program. And then we also have the guidance program. Right, so the guidance program is a remedial pre-court diversionary program for youths who have committed minor offences. So typically when a youth commits a minor offence, a triage interview is conducted by social service agencies who are actually appointed as integrated service providers by the Ministry of Social and Family Development. So these agencies will come in to really assess the youth's suitability to be placed on diversionary programs in lieu of getting charged in court for these offences. So some things that actually we social workers will consider when we do this assessment is to understand more about the risk level of the youth, the type of offence that they committed, what led to the offence, their perception of the offence, and also their ability to take some sort of responsibility for engaging in the offence as well. So if let's say we assess that the youth is suitable to be placed on this guidance program, and if let's say AGC then concurs with our recommendation, then the youth receives a conditional warning from the police, and then they are placed on the guidance program together with us. So then the social worker follows up with the youth for a period about 6 months to a year. And during this period, social workers will then work with these youth to help them to increase their awareness of, the thoughts, attitudes, and feelings which actually contributed to the offense. And we would like to then help them to have some changes in this aspect as well. Right. Yep. So upon successful completion of the guidance program and the conditional warning period, these youths do not have any criminal record. So when it comes to the guidance program as well, we work very closely with the system involved in the youth's life as well, because we recognize that while we might just work with the youth on a micro level, there's also a need to support them in other areas of their life as well, and to ensure that this change that we want to work them towards can be sustained in other areas of their life as well. So we work very closely with their parents, their family members, with their schools as well. Yeah, so these are the two programs.
Yes, thank you. And from the angle of rehabilitation and reintegration, it sounds like the guidance program is a great way of allowing the youth to slowly sort of reintegrate back into the society, having also considered the consequences of their actions. But you talked a bit earlier about the factors that social workers will use to assess whether or not someone is suitable for the guidance program. Are there cases that are just not suitable for the guidance program?
So if let's say we do our assessment and with consultations, we realize that okay, maybe this youth will not be as suitable to be placed on the program for whatever reasons, then what we do is that we will then make a recommendation for them to receive higher intervention, right? For which then AGC will have the final say about what happens to the youth after which. But most of the time, even if let's say we do assess that this youth has a high risk, but if we also make in our assessment, we realize that actually this youth high risk but has not received any offense-specific intervention, then we might want to actually recommend for them to try the guidance program out first, so that we can actually assess and see how they actually fare on this program. Because ultimately, we try our best to ensure that the youth don't have to go to the court system. We want to see whether we can rehabilitate them in the community first. So even if they are high risk, but if they have not attended any offense-specific intervention program, we try to recommend that they actually try one out first.
Okay, thank you, Aaron. We'll now move slightly away from the topic and go to James. So, James, apart from the more formal type of programs such as the guidance program, what are some other early intervention actions that social services agencies like yours support and do?
Yeah, so I'm here to also represent Singapore Association of Social Workers, School Social Work Chapter. So basically, we are a dedicated social service practitioners dedicated to working with school systems. So if you have heard of this African proverb, it takes a village to raise a child. Just imagine the village as the school system, and social workers, we will engage with the educators, we will engage with the parents and also the children and their peers to actually talk about their well-being. So take for example, in LCCS, we have this signature program called the Builders Project, and it's called that name because we believe a lot that the social worker based in the school, he's there to build, strengthen, and restore the relationships between their peers, and also even with their educators, their teachers, and also with their parents as well. So I will speak more about restorative practices later in terms of the application of the case, but in LCCS, we specialize in that quite a bit. And there are many technical definitions for restorative practice and talking about it. But one thing I will just keep it short is that we build, strengthen, and restore relationships for children and youth. And in anything we do, we look at how we can meet the needs of children and youth in three ways. So firstly, talking about voice, for every children and youth, whether they are the person causing harm or whether the person experiencing harm, they have a story to share. And it's important to hear their stories and not label them right from the outset, because the intention is not just about addressing the harm, but it's also to rehabilitate and restore relationships. Secondly, it's about belonging. So in terms of looking at how these individual and children, they are situated in the context of their class, their schools, and these relationships matter in helping them to learn about the values that they need to actually work out in their pro-social relationships. So connecting them with their school community, their class community is super important as well. And lastly, the need of agency. Every trained youth need to feel empowered in their situation, whether they have done wrong or whether they are a victim of circumstances. They need to feel that they have the ability to make things better for themselves and for their peers.
Thank you, James. We'll have a bit of time later to explore how these strategies can work in a hypothetical case, so we'll come back to you on that. Now, Muslim, back to you. Could you share with us if a young person is charged with a criminal offense, generally what is the process in the youth court? What is its philosophy? What are some of the procedures and the orders that a youth court can make?
Okay. If a young person is charged under the law, right, under the age of 16, it will typically take place in the youth court. The youth court sits under the auspices of the Family Justice Court in the Family Justice Court building. It is a specialized court dealing strictly and solely with young offenders. No adults are there, so the young offenders will not be exposed to any adults. And it is conducted in closed door settings with only the parents involved, right? And with a specific emphasis on making sure that the young offender understands what's going on, right? Through the use of simple, non-legalese language, for example, right? Using softer definitions and terms, right? So as not to stigmatize, so on and so forth. Like normal criminal proceedings, the young person will essentially have to appear in court, have to be read the charge, right? And essentially decide on how he wants to proceed. Okay, so in a normal situation, an accused person, because once you're charged, you're then referred to as an accused person. That person will have to decide whether they want to claim trial by contesting the criminal charge, or whether they want to accept the charge, admit to it, and then just mitigate, basically argue on sentence. So that same thing applies, right? The young person will go through that same process, where will be given time by the youth court to decide how we want to proceed, to decide on whether the young person wants to engage a legal representative, whether the young person will want to try and negotiate with the prosecution, so on and so forth. Eventually, the young person will have to decide how they want to proceed, and then the youth court will go on to hear the plea or administer the trial, essentially. Now, where the youth court really differs, I think, besides how it carries out its work, is in the sentencing options that are available. The youth court has at its disposal a slightly wider range of sentencing options, ranging from the more rehabilitation-centric, such as a probation order, to the slightly more institutionalized and harsher sort of punishment in the form of detention in a juvenile center or a halfway home, to the most sort of punitive under the law, for which is fines and jail terms, right? Or reformative training, jail terms, fines, things like that. Of course, that depends on, like I said earlier, the court is going to decide. I mean, not just the court, but the prosecution as well will have to assess what it deems are the most prominent and pertinent sentencing considerations there. And then the punishment will be meted out accordingly. Yeah. I think only in exceptional cases, where the crime is particularly serious, maybe, like it could be a murder charge or things like that, where the young offender will not be charged in the youth court, but rather will be charged in adult court, in the high court, for example. Yeah, but that's usually reserved for the most serious and heinous crimes. Yeah.
Yes. When it comes to sentencing a young person, it seems like there may be competing objectives and aims. So how would a youth court balance considerations of accountability, so like retribution, what you talked about earlier, and rehabilitation? How does the court navigate this tricky topic?
I mean, I think it's really it's an issue of legal submission, right? I mean, in any case of an offense, there's bound to be some degree of deterrence that's required, right? But typically, the law treats different offenses differently. If the young offender is charged and found guilty of shoplifting, it's never going to be treated or viewed in the same way as a young offender who might have be found guilty of a sexual crime, right? So I think how the law navigates it is by looking at the gravity of the offense in question, whether there is what the extent of the harm is. Is it just financial, for example? If it was financial, were the stuff recovered? So there's actually no financial loss, or does it go beyond that, right? Has it caused psychological trauma to the victim, things like that? So that affects the gravity. If there is the elements of that, right, psychological trauma and stuff like that, of course, you would expect that the court feels that deterrence, retribution needs to take a higher role in the sentencing case. So of course, if you're talking about practical situation, what will happen is the prosecution will essentially submit to the court on what the court should take into consideration and the weight that the court should give each of these considerations. And the young offender would be given a chance to respond and give its own point of view. Of course, preferably through a legal representative who knows the law and stuff like that. But it is a balancing exercise, right? And the
Yeah.
court at the end of the day has to decide how much weight to attach to these things.
Yeah.
Yeah.
So for particularly serious crimes, can a young person go to jail, for example?
Yes, it's possible for a young person to go to jail, and I think it's happened before. You can go online and find articles about prominent cases of young children getting involved in serious crimes, and the gravity of the crime just requires a harsher and more stringent approach towards sentencing, and very much so it can. But of course, that doesn't mean that, if a young offender is sentenced to jail, that there's no rehabilitation element to it, right? Because in jail itself, there are programs, that are designed to ensure that they have the ability to sort of reintegrate back into society. And just because they're going to jail doesn't mean that they're going to be lumped in with all the adults as well. Yeah. So, I think in a situation like that, where the crime requires something more serious and a harsher response, you can expect that jail term would be an option that's considered by the court, no doubt. But that doesn't mean, to my mind at least, that doesn't mean that there won't be any rehabilitative interventionist elements to it in a jail term. Yeah.
We sometimes hear young offenders being sentenced to probation. So what exactly is probation? How does it work? And what sort of factors does the court take into consideration when sentencing someone to probation?
Okay, so probation, I would say, is one of the more commonly utilized sentencing options for young offenders by the Singapore courts. It is a sentencing option that extends all the way up to young individuals up to the age of 21. Okay, it is basically this. It is a supervision of the young offender under specific conditions, right, that they have to comply with for a specific time frame. And if they do that and they successfully comply and complete that, then they will not be, they won't have any record of their offense, right? It's in lieu of a sentence and they won't have any criminal record. So this probation would typically require the court first to be satisfied that the young offender is suitable for probation. And that first stage of the inquiry requires a probation officer to interview the young person, his family members, to establish that, look, he has the social support, he has the family support, the structure at home to comply with this supervision, right? They have people who will be invested in his rehabilitation and make sure that he can comply. If the report is positive and suggests that he is a suitable candidate for probation, the court will then make an order. The court will usually state in the order how long the probation is for. So it's usually a minimum of 6 months up to 3 years, right? And during that time, the young offender will be required to report on a fixed basis to the probation officer, check in with them, undergo some counseling maybe. There could be other conditions attached, such as curfews, things like that. But why it is probably the most appealing option is that, one, it doesn't require detention in any sort of institution, anywhere else other than home, basically. And two, you get to carry on your everyday life, right, with minimum hassle. 3, you successfully complete it, you have no criminal record, right? So it's definitely something that, in my experience, the courts do try and push as far as possible, as long as the type of offense in question does not call for something much more drastic. Yeah.
Yes, so just circling back generally to the youth court procedures, we've heard that there are some special provisions that are made when a youth offender is treated under the law as compared to an adult offender. But nonetheless, it sounds like it could still be a very stressful process. So one of the elements of stress, I guess, is generated by the publicity of a matter. So for youth court proceedings, can we expect that members of the media will be allowed to attend? Can members of the public also sit in for such hearings?
Yeah, so the youth court, fortunately, is closed doors, right? And there's a gag order that applies, which means that even if the media were to report on the case, it can't name any of the individuals or any of the young individuals who are implicated, both the offenders and the victims, so on and so forth, right? So from that perspective, I think one can take comfort in the fact that it is a lot more private and contained than your normal criminal proceedings, right? Most times youth offenses will not be reported. Most times, of course, you do, of course, once in a blue moon find a case that is so, it's so high profile or it's so shocking that in the interest of public, it has to be reported and you find that those things in the media. But you will realize that the names are not released, right? And that's also by design, because under the law, where a young offender is concerned, they're not allowed to release their names, basically. Yeah, so I think that's something that, people can take comfort in. Yeah.
Okay, thank you, Muslim, and thank you, panelists, for giving us a general overview of how young offenders are managed in our society, and also some of the processes we have in place to encourage early intervention and rehabilitation of young offenders. We also talked a bit about how some of these programs help reduce the risk of reoffending and aim to help their reintegration back into society. Now, with that understanding in mind, let's now turn to a hypothetical scenario involving potential young offenders to continue our discussion on how parents and educators can manage such situations in real life. Before we go on, please note that this is an entirely fictional situation that we have created for the purposes of this webinar, and any resemblance to real life events or persons is strictly coincidental. Okay, so looking at our hypothetical scenario, Jerry is a 15-year-old student in a secondary school in Singapore. Jerry is a talented photographer and he enjoys posting his art on social media platforms, including self-portraits. Over the past few weeks, some of Jerry's classmates found his social media and began to make fun of him in class. They mock him by mimicking his poses and make nasty comments about his work in person and also online. In the recent week, the behavior started escalating, and on one occasion, these classmates accidentally shoved Jerry down a flight of stairs and he had to be hospitalized. Jerry's parents were very angry. They showed up at school, demanding to know what the school intends to do about the incident. So a very tricky situation. James, can we invite you first perhaps to share if you have encountered a situation like this, and how should parents and educators even begin handling the situation?
So in looking at Jerry's case, there are three things to note. One is the involvement of social media, where unfortunately, when things get on social media, it's no longer just between Jerry and the other student, but it becomes a whole wide world kind of thing. It could be their classmates, it could be other children in their neighborhood, it could even be people from foreign nations. So sometimes that amplifies the extent of harm, the perception of that a lot more to whoever's involved. And for that, actually, when we take on restorative interventions, there are definitely such cases. I remember they're handling one referral case from a school where one of the secondary school boys, they had a bit of some kind of conflictuous relationship with one another, of which it resulted in this student A tackling student B in a football match, and then student C being planted there to film the whole thing down to post on TikTok, and there and throughout the whole video, there was a lot of demeaning kind of remarks being made and making fun of the student being tackled in that sense. So because it's on TikTok, things got a bit out of hand, and that's where we're being asked to actually go in to intervene for this. So I shared earlier that the very first thing that we really want to look at in a restorative intervention is meeting the needs of voice, giving every party involved a voice space to share what was going on for them in that story. And we engage student A, B, and C separately in that sense, hear from them about what was going on for them, whether they have they understood after the incident, after the whole thing went viral, how are they being perceived by other classmates, and not just actually for three of them. But we also had to bring out the stories of their peers as well. How their classmates could now actually be very embarrassed to know that there are other classes looking at this their own class and labeling them as, you are the worst class because you have this kind of issues going on in that. So what we did is that we bring not just the three of them, but even their peers and classmates together in a circle, and the entire class was there, and we then facilitated the conversation in a structured way and asking everybody to share how they've been impacted by this incident. And that helped the three students involved to really understand, that it's not just a me, you, and a football match kind of thing. It's also everybody else in the community that I have affected as well. And with that, that's where they're able to understand and demonstrate remorse and make apologies sincerely. And thereafter, the whole class collectively, they all took ownership of it and also talk about how they can actually safeguard such relationships in the classroom. Yeah, so I think that was a wonderful outcome for one of the restorative interventions that we did for social media case. Now, there are also other two things I note in this case study. So, angry parent coming down to demand for action. And secondly is there is also an element I think that was said about hospitalization, which makes it a little trickier because there are financial restitutions being involved. And it reminds me of one of our case where we had a program between a group of P4 to P5 students. Let's just say in this program, this guy, pseudo named Clarence, he pushed the student B, let's call her Jeanette, to the floor, trip, and the push was so aggressive that students Jeanette suffered a elbow fracture and had to be sent to hospital. Yeah. So when we engage both parties, I think for Jeanette's parents, she was the foremost concern on the mind, of course, because she came from disadvantaged family background. So she's most concerned about the hospital bills and fees. And for actually Clarence, his parents actually were more mentioning about his ADHD condition and talking about how difficult it is to manage things on their end for this guy's behavior. But they don't know about all these things without a conversation. So sometimes a lot of things are built up in tension between parents because there's a missing conversation involved, understanding each other's perspective and circumstance in that sense. So in LCCS, what we did was that we brought the students and we courageously brought both sides of parents down in a circle together with some of their friends sitting down in a circle to talk about the issue. And when they are able to understand that, hey, each other, we have such various unmet needs in this situation, that's where so if I want to put it, the miracle happened where Clarence's parents offered to pay for the hospital bills of Jeanette because she understands how much it affected Jeanette's parents. Yeah, so I think, of course, I'm talking about a lot of some of these sometimes difficult issues about social media, angry parents, hospitalization, etc. But in LCCS, what we believe in is that the key to unlocking and solving this and is to give ownership to the community and to allow the relationships to be strengthened for them to actually look at how they can take collective responsibility together. Yeah.
Yes, so I think in our current example, we also noticed that this behavior is not new. So it started maybe from something less serious. So Jerry's classmates were making fun of him, but it had not escalated to a physical confrontation or physical action. So do you have any tips for educators on how to spot such situations before they escalate to a point of physical violence or physical harm?
Yeah. So in RP, we have this what I would call a compass of shame. So whenever students go through a shameful kind of experience, we will say that there are 4 very common ways they respond to things. So first, the most common, of course, you can see even in this case scenario is to attack others. They verbal insults, physical aggression. I think that's very clear. But on the other hand, there's also what we call attack self. So when you see students start self-harming, saying negative things about themselves, saying they are trash, things like that, that's also a good alarm bell to actually watch out for whether they are experiencing this. There are two other ones. One is denial. So total just not acknowledging about what has what's happening, taking part in a lot of risking behaviors to actually distract themselves from the issue. There's also avoidance, withdrawal, where students isolate away from the school community. So they may not come to school. They may choose in recess time to actually play by themselves. So these are some of the common things that I think whether it's educators or parents, they can actually look out for.
Thank you, James. Muslim, let's look at this from a legal perspective, perhaps. Can you share with us if any of the students mentioned have committed any actual offences, and what is the consequence if they have?
Okay. I think based on the scenario at hand, there are two potential problematic areas of conduct, right? The first would be the acts of mocking, making nasty comments online. Yeah, those could potentially be an offense under a particular law in Singapore, which is known as the Protection from Harassment Act. Now, this particular piece of legislation was enacted maybe about a decade ago to specifically address, criminalize acts of harassment, which is very widely construed, right? Basically, any conduct, any communication which is done with the intention of causing harassment, alarm, or distress could fall under this umbrella of harassment. So in a case like this, especially where it's taken place online, I mean, it counts as cyberbullying, which is one of the things that this piece of legislation was enacted to strengthen or to prevent. Okay, so it could be an offense under the law. And of course, if the authorities deem it to be of sufficient seriousness to be an offense, then the young individuals concerned would potentially be looking at intervention from the authorities, either through some kind of programs like my panelists, my learned panelists have mentioned, or by going through the youth court. Okay. Now, the act of physical violence, pushing James down the stairs. Now, that seems to be well, I wouldn't say it's the more serious offense or the more serious act, but it could potentially result in more serious consequences under the law. That potentially would constitute some form of offense against the body, right, against an individual. That would probably fall under the penal code. Penal code has various tiers of offenses, against the human body, right, depending on the seriousness. So minimally, at the lowest tier, these individuals could be found guilty of an offense of voluntarily causing hurt. If, for example, James's injuries were particularly significant, I noticed that he had to go through hospitalization. So if there are fractures, any permanent kind of disabilities, the criminal charge could automatically be elevated to something a lot more serious, like voluntarily causing grievous hurt. So these are very serious offenses. Under the law, if they were adults, they would potentially be looking at jail terms, right? Depending on how serious the injuries are and all that. So I expect, the kind of consequences they could face is potentially getting charged in a youth court, all right? Maybe considered for probation if it's not so serious. But if it's something very serious and the injuries are very extensive and permanent, there is a higher chance that they are in for more punitive measures, such as detentions, jail terms, so on and so forth.
Okay, but given these incidents took place in a school, doesn't the school have a final say on what happens to the perpetrators? And how does a court get involved in a situation like this?
I mean, I'm sure that the schools will have their own disciplinary protocols and processes to deal with this. But I mean, the moment the authorities are alerted, and it might not even be alerted just by the school, right? It could be a parent who makes the police report. In most cases, that might be the case. Once the authorities get involved, what I'd say is that our authorities will their approach takes precedence lah. The law takes precedence. I think very rarely you'd find a situation where the school's approach contradicts with the law. I think it works in tandem, right? Maybe the school providing a bit more support on the ground, whereas the law takes the more formal route, right? But I expect that legal enforcement will take precedence over whatever internal disciplinary process that the school wants to take.
Okay, so if I'm a parent of one of the young people who have been accused of bullying and harassment, and I know that the school is going to undertake some investigation and the law enforcement may also be looking at this, what should I do as a first step? What are the
If
recourse?
I'm the parent of a child who is being investigated, is it?
Correct.
So not the child who's the victim,
Not
right?
the victim, yes.
Well, I think I take a similar approach to I'm first and foremost a criminal defense lawyer, so I think I take the same approach in terms of practical steps. As a parent, I'd want to know in my child's own words exactly what happened, right? To have a very clear and, more importantly, contemporaneous record of what happened. The closer in time you can secure a good record of this, the better it will be, because you don't know what your child may say during the investigations later on and all that. So as long as you have an idea for if you have something to fall back on. I think another thing would be to try and have as much involvement and understanding of the process, right? There's a difference between knowing that there's a process going on and being intimately, intrinsically connected and involved in the process, right? Taking your children the extra mile to every, to counseling in advance if that's necessary, if you think there are red flags, bringing them to court, being completely understanding the process to be in a position to explain to your child, that really helps as well. I think the third thing that I would consider perhaps at the appropriate juncture is also to reach out in the appropriate way to the victim's parents, right? And maybe offer some kind of redress. It could be restitution, it could be something else, because those kind of things are typically also viewed favorably by the law. So for example, if in the future, the young offender does get charged in court, things like that, offers at restitution, and making things right early on will reflect favorably on that person. So I think these are some of the practical steps that you can take. Of course, as a parent, it might not be easy to accept, but you have to understand that there is a degree of control that you have to seek to the authorities. You are not in control of the process, right? And you are very much at the mercy of the authorities at most times. So I think understanding that is very important as well, and just getting involved in the things that you actually have control over, lah. Yeah,
Yes,
basically.
that makes sense. So apart from the legal process and the potential disciplinary process, Aaron, can we also talk a bit about how to support youth who are going through something like this, specifically on the persons who have been accused of bullying and harassment? What can parents, what can educators do to help them during this process?
Right, so I think one thing that almost is important is that we be careful not to label these youths, right, as bullies itself, because these labels can actually perpetuate them to continue then being bullies, because they then adopt this identity. They feel like my school, my teachers, my parents view me as the bully, then they're going to act in accordance to that as well. Right. When we address bullying, it's really important to really separate the behavior from the person and to acknowledge that while these youth's actions are wrong, their personhood, their worth still remain intact as well. And actually, when we look at bullying as a whole, the behavior is often symptomatic of something that is probably deeper and more deeper underlying issues as well, lah. So as practitioners or even as adult figures, when we come to support the bullies, we can aim to really unpack and understand the reasons behind the bullying, recognizing that bullying can stem from various factors such as maybe past trauma, unmet needs, or even learned patterns that they adopt in a survival mode kind of thing. So for example, I've had a case before of a youth who was always caught for being aggressive in school. Right, so the school would always call me and say, okay, the boy today, he punched this guy, he was aggressive towards that guy. So I took some time to try to understand him and to really see what's going on there, right? So of course, we do the thing where we attend to him, I attended to him, didn't label him, tried to really understand the root cause of these things. And in my time with him, when I was able to build rapport, I actually unpacked with him that when he was in primary school, so this boy is in secondary school, but when he was in primary school, he was bullied. So there was an occasion where actually his friends made him strip. They took videos of him, they circulated it within the school. And because of that whole embarrassing situation, he had to then change school. Right. So when we processed this, he shared with me that, you know what? When I wasn't able to stand up for myself, I was bullied. So now the only way I can protect myself and ensure that I don't get bullied again is to be aggressive. So it's a power and control kind of thing. So we see that, you know what, it's just not as really as simple as he's a bully, he's aggressive. There's a lot of other needs, a lot of other areas that contributes and perpetuates this. So as adults, it's really for us to see how we can take that time to understand the root cause of things, to unpack it with them, and then to see how we can work with them on adopting healthier alternatives to cope. For example, for this boy, it's a power and control day. It's about poor frustration tolerance. Then we work with him how we can equip him with skills so that he can better manage his emotions, how he can actually assert himself with his friends without actually using violence as a means to solve the problems.
Yes. So James and Aaron, have you guys seen cases of youths who persistently engage in such negative behaviors, even after going through, let's say, the restorative practices or going through programs, they are still repeatedly manifesting these behaviors? How do we deal with these sorts of escalated or repeated cases?
That's quite a tricky kind of question in that sense. But in counseling practice, we have this saying, which is that you can bring a horse to the water, but you cannot force it to drink the water. And of course, I think maybe we need to have a professor here who can unpack for us, some of the some of the background and context for repeated offences in that sense. But I think that for someone who is in such a situation, there could be a lot of negative life experiences that resulted in them interpreting life in a certain way, choosing to be in a certain way. I think like what Aaron has said just now, for example, that bully, he has learned that the only way to protect himself is to act out in such a way. I cannot accept any other means of protecting myself. So it takes a long time and a long time to change. But most importantly, I think looking at whatever studies, whatever not, the support system around this person is really important to help the person make change. So whether that is a parent, another sibling who share their emotions when they hear of such repeated actions, no matter how many times, I think those are the key things to help the person to consider change over the course in time as well.
Yeah, so I agree with James as well. I think when we look at youths who persistently resort to using such means, they are aggressive. When youths behave this way, what I believe is that they're trying to communicate something to us. So the youths, they all have needs. They want to achieve certain things, but sometimes they maybe take an unhelpful way to achieve these needs. And so when they persist and continue using aggression or things like this to reach those needs, then maybe they are not equipped yet with that skills, or they don't know what they can do that is helpful to help them to reach those needs that they have as well. And when it comes to this, then it's for us to really understand what are some of the hindrance or difficulties that these youths have in using more helpful means to reach these needs that they want. Right. So for example, if a youth really enjoys feeling at peace, and when people disrupt his peace, he punches the people because you disrupt my peace, I'm going to disrupt your peace. And then he feels inner peace after that. So what he wants, that inner peace state, it's not something that is wrong. In fact, it's something that most people want. But the way he goes about to achieve it is in an unhelpful way. So then for us, when we come in to support them, is really to help them to see that, hey, you know what? There are other means you can get that inner peace. If someone disrupts your peace or disturb you, you can walk away. You can let them know this is not nice, and then do something else that makes you feel better. Right? So it's all about working with the youth to help them to really adapt and learn these coping mechanisms and things like that. And also another thing is to work very closely with the systems that are involved in the youth's life. Right? Because while we might help youth and guide them to learn certain coping strategies, these kind of things must be enforced in every other environment as well. So in the school, at home as well, So then it's important to really work with the home system, the parents, to see how they can help to enforce certain things at home, to encourage the youth to actually turn to these healthier alternatives, and schools as well. Know how teachers and adult figures in school can also help to guide the youth to use these healthier methods to cope and with the situations that they are faced with.
Yes, so a situation like this with so many players involved is obviously very high tension and potentially delicate when it comes to handling and helping the young people involved. Have any of you seen any missteps by parents, educators, agencies in any of the cases that you have handled? And how can we perhaps avoid them when looking at such cases?
I think there is always that possibility because if we all work on the same case but we do in a different approach, a different kind of things we are communicating it to the youth, right? Then that missteps could happen. That's why in social work practice, all this case management, case conferencing kind of approach where we want to sit down all the stakeholders in a single setting, agree and align on some of the issues that that this youth is facing. For example, of course, the teachers, when they sit such a meeting, they'll be sharing on some of the behavioral kind of symptoms in classroom setting. So kicking the chair, lashing out, etc. And for social workers, then that's where our engagement one-to-one, we are able to bring out like, oh, actually for this youth, underlying those behaviors are this kind of motivations in a sense. So if you were to just do this school discipline process A, it may cause him to actually backfire and think that he's a rebel without cause. So that's where the case conferencing process is important. Everybody sit down, align, agree on the approach, and then we agree on how do we tackle in a kind of a time-based kind of way and look to rehabilitate the youth.
So for social services agencies who may become involved in these sorts of cases, how long do you follow through a particular case? Is it just one-off, meaning you address the current situation and that's it? Or do you actually follow the young person through? And if so, when does it end?
So typically, if we are looking at programs wise, we will, let's say a youth is referred to us for support and the presenting issue is aggression, then we will continue to work with the youth, not just until the end of that one episode, but we really want to strengthen the youth skills and ensure that they can end up being individuals that thrive, right? It's not just to stop the symptoms, but to see how we can actually get them to be contributing members of society, how they can thrive in life and things like that. So we will work on the issue with the youth, but aside from that, we will also work on seeing how we can engage the youth in other aspects of things as well so that they can be groomed holistically as well. So many times we actually involve these youth in what we call interest-based programs because we find that a lot of our youth, they don't have the opportunities to actually thrive and to be engaged in things that are meaningful for them. Right. So when we create these opportunities for them and we involve in them, then we are giving them the opportunity to actually do things that are good for themselves as well. Yeah. So when it comes to a time frame, there's no fixed time frame in how long we work with our youth. But what we do is that we have periodic assessments that we certain markers that we look out for to actually ascertain whether this youth is ready to be able to have their case closed with us. At the end of the day, we don't want our support to be there forever. We come in for the interim period to build their skills, to give them opportunities, after which the best indicator of success is we are able to be independent and they don't need us anymore as well. So that's when the parents can continue to support them, the home system in the home setting as well.
Thank you. So just zooming in again on the hypothetical, Muslim, can we ask you perhaps, if Jerry's parents were to come to you, for example, what are the specific legal remedies that are available? We touched a bit on jail, on the Protection of Harassment Act, but what actually are remedies that they can have recourse to?
Sure. I guess first and foremost, the most direct remedy available to the parents in this scenario, and actually in most scenarios, would be to make a police report, right? For the criminal offense. You essentially be making a police report either online or in person at a police station. The police then goes on to investigate the matter and make a recommendation to the Attorney General Chambers or the public prosecutor on whether an offence is made out. Right? At that juncture, the authorities decide on whether to channel the youth offenders to the more interventionist side of things or to more institutional formal process, right, by charging them in the youth court. So first and foremost, making a police report is essential, right, getting the authorities aware of these things. Now, second, aside from the police report and the criminal liability aspect, if Jerry's parents would come to me, I think one of the other options that I would want to present to them is seeking protection under the law pursuant to the Protection from Harassment Act. Now, if you remember, I mentioned just now about this piece of legislation, the Protection from Harassment Act. Aside from criminalizing certain types of conduct which could constitute harassment, the provision also provides remedies in the form of protection orders, okay? So an individual can apply to the Protection from Harassment Court for an order that prohibits another individual from doing certain things, right? So in this case, it could be prohibiting the other individuals from publishing insulting comments about Jerry online, even communicating with Jerry, right? Or even coming within a certain distance of Jerry, things like that, right? So this essentially involves applying in court, starting a civil court process or a quasi-civil criminal court process where you're applying for this order, where you show the court that, yes, one, this person has committed harassment, and two, the harassment is likely to continue, all right? And for protection order applications, the court and the law is obviously sensitive to the fact that time is of the essence in these things, right? Especially when the harassment is ongoing. So the court tries to process and hear these cases quite expeditiously. And there is an option for the harassed individual, the victim, to apply for a temporary expedited order, which can be put into place pending the confirmation of the final order. Okay, so what is the effect of this order? Basically, you now have a court order prohibiting an individual from harassing you, right? And if that person breaches that order, then all the more the police will take action and they will take harsher action. So in the absence of the order, of course, in very, very egregious cases of harassment, cyberbullying, the police can take action, right, on the basis of the Protection from Harassment Act. But in some situations, right, the police may decide that it's not sufficiently serious for them to take it first. You will require a party to go to the Protection from Harassment Court, get that order, right? And then if that order is breached, then the police will step in and take criminal action. So these are the two main options that I would say are available based on this scenario. Yeah.
Yes, and do the police have like a specialized department dealing with young offenders or people who are trained, for example, to interrogate young offenders? What sort of guardrails do we have in place to make sure that young offenders are treated appropriately in the same way that James and Aaron mentioned earlier?
Okay. I'll be honest, I'm not 100% sure whether there is a dedicated youth department. What I expect is that, what I understand, at least from my limited knowledge of how the police operate, is, they have different departments depending on the types of offenses, right? So, of course, if a youth offender is involved in a more serious sexual crime, then you have police officers who are specifically attuned to these type of offenses. And then you have the additional safeguards under the law, such as the appropriate adult schemes and stuff like that, to make sure that the authorities, the young offender has some sort of distance and barrier from the authorities, some sort of protection and safeguard. I can't say 100% for sure though if they have a specific department for the youth. I'm rather not. I'd rather not second guess that, unfortunately. Yeah.
Yeah, so just pausing on appropriate adult scheme, will the parent of the youth offender know who the appropriate adult would be, or do they get a say in who the appropriate adult would be? I know we said earlier that can't be themselves.
I don't think that they have a say, and in fact, from my knowledge and experience, in some cases they may not even know about it, right? I had a client previously who was, I think he was about 16 years old, and he got caught. Basically, he was out with his friend all day, right, and doing normal stuff, nothing illegal. But at some point, when they were feeding cats under the block, they got screened by the police, as you do. As a 16-year-old loafing around under the block, you get screened by the police. And his friend, unbeknownst to him, his friend had a knuckle duster in his bag. Okay, so that's immediately potentially an arrestable offense because it's a dangerous weapon, right? So what happened was, because it was at night, he got brought into the station. The police tried to call his mom, but it was past midnight, so she didn't pick up, or she was asleep or something, right? And so they went ahead with the interview, right? And I mean, the parents had no idea about this, had no idea that this was going on. The interview took place with a third party adult present, but they only came to know about it the next morning, right? So, I mean, if you're asking whether they have a say in it, I don't think so. If you're asking whether they'll know about it beforehand, they may not even know about it. I mean, depending on the situation, it's very possible that they only find out after the fact. Yeah. And unfortunately, that's the reality of things. I think had it happened at a different time of day, it appears that the police did try to call the parents in advance. So maybe they would have known who was going to be there and all that. They could even be in the police station, although they won't be in the process itself. They could be at the police station waiting and all that. But they didn't pick up, and we went ahead, right? So, I mean, that just tells us that it's very possible that, I mean, it really, to me, it reiterates the fact that for at least in the preliminary stage of the investigations, you are at the mercy of the authorities, lah. Yeah, and that's something that we have to sort of come to terms with, I think.
Okay, thank you. We are having a lot of questions come in, but I think in the interest of time, let's continue with our hypothetical scenario so we can explore some of the other topics. So more on the story that we were following with Jerry. Further to pressure from Jerry's parents, the school interrogates the students and searches their belongings, including checking their phones. While looking at one of the students' phones, the school discovered that one of the students had used several of Jerry's self-portraits to create deep fakes, nude pictures of Jerry, disseminating it to classmates and also putting it up on the internet. Upon questioning, this student also confessed to having a pornographic addiction. So, Aaron, we come first to you. Just any thoughts on what is the appropriate action here? I mean, there are a number of issues that obviously we have to deal with, but what is the first thing you think parents or educators should do upon this discovery?
Right, so I think when parents or the school discover that the youth is firstly consuming pornography, what's important is that the adult figures respond with understanding rather than punishment or shame. Right, because if let's say we come in from a point where we are going to make the youth feel shameful of the act, then we are actually closing them up and we are reducing the chances of them displaying help-seeking behaviors as well. Because we can't really work with shame, but what we can do is to really try to understand where they're coming from and what actually feeds this behavior, lah. So, when we look at our youth developmental stages, right, we know that sexual curiosity is really normative. It's part about growing up. It's how they develop. But, when they go through this whole process of puberty, it comes with the development of both in the primary and sexuality and sexual secondary characteristics as well, lah. So it's really a normative process. But what happens is that when they are not guided through this process, then they learn about these values that are about sex and things like that from pornographic videos that they consume, sometimes even from newspaper articles that they see that maybe talks about sexual offenses, and then also from discussions that they have with their friends as well. Right? So this is where they develop maybe sexual scripts that are non-normative, and then it becomes an issue after which as well. So for adults, we should really provide that safe space that is really non-judgmental, right? For these youth to really talk about sex and related issues as well. Shaming, labeling them will reinforce guilt and hinder their help-seeking behaviors, like I mentioned earlier. Right? So instead, we should seek to understand the underlying reasons for their actions. If let's say, this youth was involved in making a deepfake video, right, that is obscene in nature, we want to understand a bit more about his own understanding of the offense of what he did, what actually perpetuated it, what led him to believe that this is something that can be done, whether it was sexually motivated or whether he did it out of fun. We want to find out the root cause of it, and then we see how they can actually express themselves or do things in a different way where they don't end up hurting other people as well.
That makes sense because the person creating the deep fix may not even think it's something wrong. It might be something funny or something they have seen other people do. James, anything to add to this?
Yeah, unfortunately, this is the issue that we have to grapple with the advancement of modern technology, where at the fingertip of a person, you are able to create such things. And I think as Aaron and Hannah, you already shared that when they do it, they come from an angle of thinking this is a fun thing to do. It's very fast for me to click here and there and generate that image. And then I think studies have also shown that at that age, neurologically, I think for the youth, their prefrontal cortex, that means their brain are still developing. So their understanding of what are the consequences or how you impact others is sometimes limited as well. So I think that's where it's also important to have to understand that in doing this, they're objectifying other people. They are seeing other people as an entertainment tool for them, and they are not seeing them as fellow human beings who feel hurt, who feel who get shamed, who get embarrassed, and is unable to carry himself in front of their peers when this happens. So again, it goes back to that conversation that these youth need to have with the victim or even to others to understand the extent of the impact of harm they have caused from just what they think is a fun thing to do.
Thank you, James. Muslim, can you enlighten us perhaps? Is it illegal to create deepfakes and what are the consequences of creating something like this?
Yes, it is illegal in Singapore to create and distribute deepfakes. There is a specific section in the penal code which sets out a list of sexual offenses, right? Everything, extending from very serious sexual offenses such as rape to something that's a lot more less serious, such as like sexual communication, right? Things like that. So one of these offenses relates to deepfakes. There are provisions criminalizing the creation, distribution of intimate images, okay, of individuals without consent. And this also extends to images, altered images where, you put someone's face on a naked body, such as in question like this, that constitutes a criminal offense under the penal code. And I mean, it is understandably treated as a very serious offense under the law. And that, I think, is also reflected in the maximum punishments that can attract these type of offenses. Distributing intimate images under the law can result in a sentence of up to 5 years imprisonment or with fine, and can also be punished with caning in certain situations, right? So I think this sort of underscores the seriousness of these types of offenses under the law. And the law is certainly, trying to catch up with the advancement of technology in these things. I read in an article a couple of weeks ago, I think, that they are planning to introduce changes to the law in relation to deepfakes, especially. They're trying to amend the law to cover AI-generated images, right? Because currently, our idea of deepfakes is like taking a person's picture and then putting on another thing. But AI-generated synthetic images, they create something out of nothing. So, it's something that the law is alive to. Legislature is trying to make enhancements to the existing provisions to take into account these new realities, lah. Yeah.
Thank you, Muslim. Maybe we can quickly move on to the last part of our hypothetical before we take some of the remaining questions. Please feel free to continue sending in your questions on Pigeonhole while we go through the rest of the hypothetical. So during the search of the students' belongings, the school also discovered several vapes, a very hot topic currently. It's unclear if it belongs to the students who deny any knowledge about it. Now, Muslim, what should educators or the school do about such a situation, and what is the consequence of being caught with a vape in school?
As you may have read in the news, right, and as you rightly pointed out, vapes in Singapore has been a hot topic, for quite a while. Singapore legislature has made sweeping changes to the law to strengthen its laws in a bid to tackle the vape problem amongst the youth. For example, right now, under the law, for first-time offenders, and I'm just talking about students only, first-time offenders who are caught with possession or use of vapes are typically given a composition fine of up to $500. Okay, so they can pay off the fine. They don't have to attend court, right? It's more like a summons. But the moment you are a repeat offender, you start to have to attend rehabilitation. You will eventually, the more it happens, the more likely you're gonna be brought into court, and you'll be charged for the possession of the vapes, and you may face more serious consequences. If you ask me what the school should be doing about it, I would say obviously the school needs to take steps to investigate the ownership of the vapes. I understand as well that MOE has implemented more stricter disciplinary measures which are required of schools in the case of vapes. I think that was put into place quite recently, actually, this year. So, the schools are required to take steps to investigate these things and impose responses such as detention, suspensions, and stuff like that in response. Yeah, so that's what I would say. Yeah, I think.
Thank you, Muslim. So, James, what can parents in particular do in this sort of situations? I think we've all seen the videos of parents who videoed their kids who are addicted to the vapes and the drastic consequences that comes with it. What would you say to a parent who comes to you with this sort of situation?
Yeah, so if we look at this case scenario, it clearly says that the students deny any knowledge about it. So if I may bring back to my earlier conversation about what are the common ways, some of the that youth could demonstrate their responses to shame, and denial is one of them. So definitely, first of all, if as a parent you're coming in from a blaming kind of approach right from the start, and you ask this youth, Jerry, why did you do it? It's more likely than not the youth will shut down and they may not give you his perspective or even the real reasons of what is going on. So it's important for the parents, of course, firstly to manage their own emotions and shame experience first. Maybe the teacher could have caught and then you feel embarrassed and everything, and the very next thing you want to do is to blame the youth. I think you have to hold that back first, because if you bring this version of yourself to engage the youth, I am quite sure the youth will not want to engage with you and shut down in that sense. So giving that safe space for the youth to share his side of the story, share his perspective, I think more likely than not, assuming that the youth is really responsible for this situation, he will come clean in that sense. And I think the second thing I would say is that in your conversation, it's also important to unearth the motivation. Suppose he's the one really vaping, like what is his motivation to actually be engaging in this behavior in the first place? I don't think it's very different from, say, issues that we dealt in the past, for example, in smoking, in that sense. Sometimes this vape or smoke because it's peer pressure. Everyone is passing the device around, and it will look uncool for me if I will not try it. I think there are also instances where maybe the youth could be using it as a way to cope with their stresses also. Like, studies is too stressful, going through this family situation is too stressful, that's why I did it. Yeah, so it's important to identify all this so that when you can address the issue, you go to.
Thank you. Aaron, anything to add on this topic as well?
I think James summed it up very well. Right? I think similar to what I mentioned about bullying, vaping we see as symptomatic of something else. It could be because of peer pressure, they want to fit in with their friends, or because it's exam season, they're stressed and they know that vaping is the only thing that can help them to feel more at ease. Right. So what we want to do is that instead of causing them to feel shameful for the act, instead of blaming them, instead of scolding them or ridiculing them, or using the law to scare them, right? I think what's helpful is really to have that conversation with them and understand, what goes behind this addiction, or even if it's an addiction itself as well. So we discover and unpack with them the rationale and the reasons behind it. I think one thing that I'm thankful that while their laws have been placed in a way where our youth eventually might have to answer for vaping offences, we also have this provision where if our youth voluntarily come and seek help, they want to stop vaping, and they seek out social service agencies that run vaping cessation programs, they will not be penalized. So for example, every year we also have a vaping cessation program that we run. So these youths that approach us and they sign up for this, what we try to do is that we really want to understand the motivation. We then acknowledge that temptations will be there. We want to address and talk to them more about, what other coping strategies they can employ to deal with stresses they face. We also get the parents on board. right? We work with the parents to understand more how they can actually journey with their youth to help the youth to find healthier alternatives as well. Yeah, so I think these are some things that are important to really try to understand, come from a curious position, trying to understand the rationale behind things. And then from there, once we understand the rationale or the reason why they are actually beeping, then we can work with them to see how we can actually get them to change their habit and adopt healthier or other alternatives to help them to cope with things.
Thank you, Aaron, and thank you, panelists, for taking us through the hypothetical. We do have a few remaining questions that came in, so we're going to try and deal with them in the time that we have left. First, maybe we go to James. There are some questions about punishment and restorative practice. Are these two sides of the same coin, completely different, mutually exclusive? How would you view the value of punishment in under the strategy of restorative practice?
So some public members or even sometimes even educators, they have this misconception that because restorative practices look a lot at conversation and dialogue, you see of it as a soft approach, because you're talking and talking and talking and talking, and so where's the real consequence in that sense? But I want to maybe put across to us in another way that sometimes letting some of these whether it's hardcore person causing harm perpetrators, to put them in a conversation with the person they have been affected, actually that is emotionally difficult for the person to acknowledge. I think sometimes we have children or youth who tell us that just give me the consequence. I don't want to sit through this conversation piece because I don't want to hear what they have to say because it affects me in that sense. But having said that, restorative practices does not exclude consequences. There is still the school rules and still the legal side of things, which are important there to safeguard certain protection and structure for children and youth well-being. But what we are wanting to also say is that let's also make meaning help the children and youth to make meaning of these consequences that could be meted for them. So for a child, I think we all have, I don't know, at least for me, like when I was a naughty boy in school back in the past where I was asked to maybe do detention in a sense. And sometimes if you sit down there and all you do is stare at the wall, there's nothing in it that gets you to connect the consequence with what you have done. There's nobody who process that with you. And what we want to do as restorative practitioner is to make the consequence meaningful for those who have been meted with it. So, and the way to make it meaningful is to understand the impact of harm that you cause on others, cause on relationships, so that you know that we are doing this, you are not breaking school rules, you are damaging a relationship you have with another person. Yeah.
Thank you, James. Aaron, we talked about this a little earlier about warning signs that identifies youth might be headed towards trouble. But I think it's an important topic. Could you maybe summarize what are some of the early warning signs that parents and educators should look out for to sort of deploy these early intervention strategies?
Right. So I think there is no fixed guide that can help us to understand what are some of these warning signs. But I think when we look holistically, we see that maybe the youth is starting to become more detached from the family. I think that's one thing that we look out for. But also we need to also understand that, youths are at a stage of development where they're trying to figure out who they are as individuals, separate from the family. So certain levels of it is normative, but we see that maybe there's drastic changes in their behaviors and things like that. And we see that they are heavily relying on their friends for support, and you see that there are certain changes in terms of their habits, their characteristics, and things like that. Then maybe we want to have a conversation with them about what's going on as well. But again, when we have these conversations with our youth, we need to also then be very careful how we broach this topic. Because if we're going to come down from a top-down approach, we're going to ask them, hey, why are you spending so much time with your friends? Why are you coming back so late? Then we're just going to met with resistance. They're just going to close up even more, and then there's no entry point after which. But if we're coming from a position of understanding, trying to generally understand what's going on, let them know that, we're here because we realize some things are a bit different and we want to understand what's really going on. Who knows, they might be more receptive towards opening up and sharing about certain things or stresses they might be faced with. And then we will then be in privileged positions to see how we can come in to support them better as well.
Thank you, Aaron. We are unfortunately out of time. So before we close the webinar, I would just like to invite each of our panelists just to leave us with one key takeaway. Maybe we start with you, Muslim.
Okay, so I guess my takeaway would be more of the legal centric part. What I would say to parents who have children who are involved, you can, take some comfort in the fact that the law does try its best to accommodate and cater for young offenders through the introduction of safeguards, through the introduction of early intervention and things like that. However, it's still, I think the parents' role is still absolutely critical in navigating this process and making sure that, not only the child can go through it safely, and understand what's going on, that he can come out of it better for it lah. So I see I see a parent's role just as exceptionally important in doing all this. And I come from a place where I've represented younger clients, and you can see like where in situations where a parent is heavily involved in a child's life, or where a parent just doesn't know what's going on, right? And that kind of thing can affect the outcome of the case as well.
Thank you, Muslim.
Sorry, long takeaway.
And on to you, James.
Yeah, I had to negotiate for two takeaways. Unfortunately, we should make it longer. And the first takeaway is important because my boss, I think I'm saying it as a promotional piece in a sense, like we're having an upcoming restorative practice conference on the 30th to 31st. If you want to really know more about restorative practice and how it works, you can always come to the conference. It's lccsrpconference.com. I believe my colleagues who are there in the chat will help plan this link there. And on the third day post-conference event, we have a very interesting activities called Circles of Life, where we're inviting people who have been have experienced social issues before, including people who experience harm as a victim, or if people who have been incarcerated before, to share their stories, to share their journey, and to invite people to listen to their stories. So if you are curious about that, I would really encourage everyone to come. On to my second takeaway. There is this Australian criminologist who asked a very interesting question. His name is John Braithwaite, and he asked this question of why do most people do the right thing most of the time. And in his academic studies, he finds that it's not because of the fear of punishment, but it is because of the relationships, the social bonds, and the moral commitments that they have towards their community. So if we come back to the children and youth again, they are still developing, they're still learning about all these things. They won't be thinking like, suppose if I do this action in this way, I will get one stroke less of the cane. If I do it in the other way, I will get away with a lighter consequence. A lot of times they don't think, they think it's fun and just go into it in that sense. So I would say that, of course, I understand this law awareness week in a sense. There's an important part about the law, legal frameworks to safeguard and protect the safety of our children youth well-being. But there's also the other part, which is about the relationships that they have with their peers, their family members, people who believe in them and trust in them, and who will journey with them a long time, that will help them to make the change on their behavior from the bottom of their hearts.
Thank you. And lastly, Aaron, to close the show.
I think all of us have been youths before, right? We understand the pressures of, navigating friendship issues, academic stress, trying to find out who we are as individuals and things like that. I really believe that no youth is inherently bad. It's just sometimes maybe because of their circumstances, they make poor choices. They end up maybe doing things that are considered offenses lah. Right, so I think as adults, we hold that privileged position to be able to journey alongside these youths and help them to navigate through this period of storm and stress that they are faced with, and really guide them, to grow towards growth, to build resilience, and to help them to navigate through this path as well. So instead of always coming down from a perspective where we want to discipline them, we want to school them, we can build relationships with them, like what James mentioned as well. And relationships go a long way when it comes to
Perfect note to end on. Thank you so much, panelists. Our next webinar will be on family violence, legal protections and support, happening tomorrow, 23rd October at 7:30 p.m. This session will explore the legal remedies available under the law, including protection orders and expedited support measures. You will also learn how to recognize warning signs, how social workers step in, and where individuals and families can turn to for help. Whether you're seeking this information for yourself, a loved one, or your work in the community, this session will offer clear guidance on how to respond and support those affected. This and just 3 more webinars are part of Law Awareness Weeks at CDC 2025. You can click on the link shared in the chat function to visit the website and to register for the next webinar or many more webinars available. If you missed any of our webinars and wish to catch the ones that you've missed, the recordings of all Law at CDC webinars will be on Pro Bono SG's YouTube channels 2 weeks after the end of the live webinar. You can also check out the link shared in the chat function. If you miss accessing any of the links shared in today's webinar, please do not worry. All the links will also be posted in a follow-up email that will be sent to you. Do look out for it. After today's sharing from our panelists, if you find that you require legal guidance on any legal issues, do write to help@probono.sg. And lastly, we would just like to express our gratitude to Muslim, James, and Aaron for sharing their knowledge and experience with us today. And with that, on behalf of Pro Bono SG, we would like to thank you all for joining us today and have a good week ahead.